Good morning, my beautiful babes and babettes. I'm your resident active advocate. And before we get into the meat of today, Lily made a boo boo, or a few. Okay, so in the AODA itself, there are no stipulations about education access. Okay, that is written into Canadian law that students with disabilities need to be accommodated in their classes and in the various institutions where they go to school. But that's not part of the AODA specifically. Employment, however, is. So I'm going to talk about that on its own today. But other boo boos that Lily made. Um, Access to indoor spaces is actually written into the Ontario Building Code, not into the AODA. So there's a difference there as well. Again, it's still like we, by law, have to be able to access the spaces that we go to, live our everyday lives, go shopping, go to class, go to work, la-di-da, right? But that's part of the Ontario Building Code, not the AODA. And it only actually applies to brand new constructions. People will go back and retroactively fit things into older buildings, but to be fully accessible, you only have to be a new building, okay? So there's also that. And there were a few others, I think, but I will get to those when I address their respective videos. Today, though, I wanted to talk about disability and employment. Now, yesterday I had said that I wasn't sure whether there was a specific stipulation about employment in the AODA. Yes, there is, thankfully. But it doesn't just have to do with being able to access your place of work physically. Like, it's not like there has to be a ramp into the place or an elevator or whatever. That's part of the Ontario Building Code. What the employment stipulations are about is that one be accommodated on the job when they are on the job. This applies to people coming into the job who already have a disability, but this also applies to people who gain a disability while on the job. Not necessarily because of workplace accidents, that's its own beast. But say if you have, I don't know, an accident outside of work and you have to have, I don't know, maybe your arm amputated or something like that. You are entitled to workman's compensation, of course, but again, that's not part of the AODA. But when you come back to work, you must be given a position at your workplace that can accommodate for your needs. So let's say you had worked at a supermarket stocking shelves. You can still do that with one arm, okay? But it might, until you adapt to the needs presented by your new disability, it might be easier for you to do another kind of job first. Maybe you can work your way back into your former position, but if you can't, then your employer is legally required still to find a job for you at your place of work. It could be your old position but accommodated for in some way, or it could be a new position that they find room for you. Now, a lot of the time, these laws are treated as add-ons, but in my eyes, I really don't think that they are, because the more people you can hire, the more people you have working for you, the more people you have working for you, the more money you can make as an institution. However, few drawbacks to the AODA is that if you have under 50 employees, you do still have the requirement, the legal requirement, to fill people's accommodation needs, but you do not have to have a systematized, framework of how to accommodate for people's needs. So let's say you have a deaf employee. but you have less than 50 employees, okay? So you don't have to have it written into the contract or any documentation to do with the job that a deaf employee will receive this specific accommodation. Now, if it has to do with anything to do with communication, there are several ways of doing this, but for a specifically deaf employee, there could be the use of sign or there could be the use of captions. Now, if a person's preferred method is sign, that should be allowed for, and that legally accommodation itself has to be allowed for. But if you don't have someone who can speak sign, then you are at least required to give captions to, say, a presentation that's going on at work, right? So if you're at a work meeting and you don't have a sign interpreter, someone does still have to present you with the capability for captions for what's being said so that you can read and follow along. If you are, say, a blind employee, it's the same sort of principle. If you need things to be done for you in Braille, then that technically only needs to happen if you have 50 employees or over. That sort of thing needs to be systematized and written into the job description, the job contract, basically the outline of what this workplace is able to offer you. If the workplace has fewer than 50 employees, and again, this is only applicable in Ontario, this is part of the AODA, then instead of Braille, you might get someone, talking you through a process, interpreting for you in that way. Systematized, 50 plus. Non-systematized, fewer than 50. Okay, that's basically the rule to remember. This, in my eyes, is a bit of a compromise, shall we say. Not necessarily either to the benefit of the person with the disability, because if you're going into a workplace not knowing exactly what to expect, and if your employer doesn't already have plans drawn up because you have fewer than 50 employees working for you, then it would be my responsibility anyway, but my responsibility to ask for specific accommodation. And if they can't give me that specific accommodation, they have to give me another form. If, however, they have a systematized thing, which is 50 plus employees, then I am basically guaranteed a level of accommodation that I don't necessarily have to ask for in specific terms. Okay. Legally, I have to be able to access the place. Like, let's say the usual example of I'm a wheelchair user or a walker user, that kind of thing. That is part of the Ontario Building Code. But once I'm actually in and once I'm actually hired, then my accommodation is both up to me and up to my employer. Some employers will be nasty about it, most won't. You have to give people the benefit of the doubt. But when you are an employer and an employee comes to you in good faith asking for accommodation, you have to give it to them. That's the thing. If you don't have a systematized way of doing this, then it is your responsibility and the employee's responsibility to communicate together to figure out how to work this thing. So that's basically the idea behind disability and employment. And there are other things that need to be done, of course. Like workplace discrimination obviously is not permitted. And I mean, even once you're on the job, like people aren't allowed to say, oh no, you don't get this because you have a disability, or oh no, I don't need to provide you with XYZ because you have a disability. These accommodations are not, quote, add-ons. They may be viewed that way, but that is for lack of understanding, quite frankly. And I talk about this all the time in my series, as you know. So don't treat it as an add-on, treat it as an opportunity for your business to gain a worthwhile employee. Because if people have the required accommodations. They're going to be able to do better work. They're going to be able to do more work. They're going to be happier, and happier employees actually produce a lot more than employees who feel as though they're, under compulsion to do what they're doing. So that is my video about employment and disability. And tomorrow, for fun, I think I'm going to look at transportation and disability. You heard me talking yesterday about the system known as paratransit. We're going to go into detail about that, and that's going to be fun for everyone involved, especially me. All right, I will see you tomorrow. Bye! Mwah.